Hi, this is Brian Dolan with the law firm Troutman Pepper. On a monthly basis, Troutman partner Greg Nowak holds a investment management and private funds roundtable. This month, Greg provided a summer enforcement action review, including raising money in a pandemic. He was joined by Evan Katz for a candid review of the investment management space after the summer of 2020. Topics they covered included recent enforcement actions by the SEC, including crypto and MCAs, the CFTC compliance manual release and the enforcement priorities, discussing expenses and disclosure issues, and also, as we said, raising capital in pandemic, particularly talking about 506C. This podcast is a recording of that roundtable. If you're interested in the slides provided during the roundtable, visit the Insights section of Troutman.com where this podcast is posted.
Good afternoon, everyone. This is Greg Nowak. I'm a partner at Troutman Pepper Hamilton Sanders, a AmLaw 50 law firm located in the United States. And I'm a member of the Corporate and Securities Group. And those of you who followed these programs before know that I am the host of the Investment Management and Private Funds Roundtable, What's Happening Now? So without further ado, I'd like to introduce my co-presenter today, Evan Katz. Evan, would you care to introduce yourself, please?
Yeah, thanks, Greg. Hi, my name is Evan Katz. I'm a managing director of Crawford Ventures here in New York City. Crawford, as many of you may know, is an alternative investment firm focusing on hedge funds in particular that helps in a variety of ways, most frequently with fundraising based on our relationships with several hundred institutional investors and family offices. I'm also a twice-elected director on the Hedge Fund Association Board of Directors, in which I served for about 6 years. And it's great to be with you today, Greg. Thanks for having me.
And thank you, Evan. And also, Evan, if it seems like we know each other, we've known each other for a number of years, and Evan is also a very valued client of Troutman Pepper Hamilton Sanders. So thank you, Evan, again, for taking time out of your day and joining us for this program. Before we get started, for those of you who are listening on a tape delay, obviously this is not quite as relevant, but for those of you listening live, today is September 30, and it is the Neonatal Intensive Care Awareness Day, National Neonatal or NICU Intensive Care Awareness Day. And the reason why I bring that up is 27 years ago, my daughter Elise was born as a preemie. She was only 25 weeks gestation, was 1.5 pounds. And the nurses and doctors and staff at the Holy Redeemer Hospital NICU are credited with saving her life. And today she is a beautiful college graduate, magna cum laude, and a teacher, and doing quite well. So she is not only the mouse that roared, but the mouse that continues to roar. So again, congratulations to all those NICU nurses and doctors who perform miracles every day. All right, without further ado, our program today is focused on, first of all, an update of what's been happening with the SEC and the other regulatory agencies during the summer. We normally take a hiatus in July and August from the Investment Management Roundtable, so we're going to do a quick update on some of the actions and activities that have occurred during the last 2 months or so. Then we're going to focus on raising money in a pandemic, as well as some other issues along the way. But and Evan, because he is a registered broker-dealer, registered representative, is someone who can help with particularized information about raising money in a pandemic and some of the experiences he has seen over the last several months. But before we get there, we're going to talk about some recent events, and we're on slide 2 if anyone is following along on the slides. So the recent enforcement actions, some sponsoring broker-dealer clarifications from FINRA, the CFTC compliance manual, continued focus on expenses and disclosure, and then, of course, the raising money in the pandemic. So going to the recent actions by the SEC and FINRA, we're now on slide 3. These have focused during the summer in crypto, merchant cash advances, advisor cross trades, and then, of course, the sponsoring broker-dealer issues. Going to slide 4, those who are familiar with initial coin offerings or so-called tokens know that these all were the rage a few years ago. Lots of money was raised. People took positions that these quote-unquote coins or tokens were not securities. The SEC allowed this to develop over time and then came down with the sword of Damocles, pretty much staking out the position that unless you are a widely dispersed and held coin that acts like a medium of exchange, sort of like Bitcoin or Ethereum, that most likely if you issued an interest that was tied to a business or a pool of assets, that asset was in fact a security or so-called security tokens. And so the themes that we've seen with the SEC on initial coin offerings and tokens are that the SEC has determined them to be securities. This is consistent with major regulatory agencies around the globe, and most law firms and other practitioners now embrace the concept and embrace regulation that if you're going to issue a token, you've got to follow the 33 Act, the 34 Act, the Advisors Act, etc. In each of the cases where we had an issue, the issuers did not register their tokens with the SEC, and they did not attempt to invoke an exemption. So one of the things we will talk about later is the so-called Jobs Act exemption for quote unquote general solicitations in the context of a private placement under Regulation D. And so there is a way to do this, but you have to quote unquote dot I's and cross T's. In other instances with the ICOs, they had allowed immediate trading in the secondary market. Now, this is an issue that a lot of people fail to focus upon, and that is that securities cannot trade in the secondary market unless, again, they are registered under a 33 Act registration or a Reg A plus registration or a Reg A plus registration, or they are trading in the secondary market among accredited investors from the Surface Transportation Act that came out a few years ago, new Section 4A7 of the Securities Act of 1933 that allows for secondary market trading among accredited investors, provided certain information is made available, or unless the instruments are essentially held, quote unquote, on the shelf for a period of 6 months until the restrictions lapse under the 33 Act, in which case they can become immediately tradable. In these instances with the coins, generally they did not provide disclosure about the risks associated with the instrument, the legal risks, and all of the other things that lawyers obsess over with good reason. Investors should know what information they need to know that's material to them in their investment decision and in their holding decision. Some of them were scams, and rightfully so. The sword of Damocles should come down on those that are deemed to be scams. And one of the questions that I often get is, well, how does this differ from a so-called blank check SPAC or SPAC, Special Purpose Acquisition Company? Both raise risk capital. In the case of a SPAC, you're relying on the promoters of the SPAC to find a business and essentially convert it into a publicly traded company. But the difference is, in the SPACs, the promoters have registered the offering, they've disclosed, and can't give you enough incentive to disclose the risks, the operations, everything that someone might find material to their investment decision. And the money raised was actually safeguarded in real custody accounts. It wasn't diverted to personal activity. So now let's go to slide number 5. Quick glossary here. What is an ICO, an initial coin offering? What's an MCA? It's a merchant cash advance. What's a participation? It's a contractual interest. And we hear this a lot coming out of our banking brethren who say, oh, we'll just do a participation in those underlying assets. Is it a security? Well, it depends on the nature of the participation and how it works, and whether or not there is an alternative regulatory regimen that the regulators can point to. So participations among banks, absolutely not an issue. Banks and the Office of the Comptroller of the Currency and the FDIC control those. But if you have an individual who says, I hold a pool of assets and I'm going to allow you to participate in that, the greater likelihood is that is falling into the category of what's known as an investment contract. And if it's an investment contract, we then have to run the gauntlet of what is now the famous Howey test. And the Howey test can be boiled down to 4 factors. We're now on slide number 6. Do you have an investment of money? Is it in a common enterprise? Is there an expectation of profit from this investment? And is that expectation based upon the efforts of others? So in the orange groves that were being touted in Howey back in 1946, Orange Grove participations, yes, there was an investment of money. Yes, it was in a common enterprise. You owned a portion of a particular grove or row of orange trees. Was there an expectation of profit? Absolutely. And were you reliant on the efforts of others? Yes, because even though you owned the orange groves, you weren't out there picking the oranges, harvesting the oranges, turning them into orange juice, and then selling the orange juice to wholesalers who would pay you cash. You were reliant wholly on the efforts of others. And that test has persisted since 1946, and it is the test that the SEC uses in evaluating whether an initial coin offering trips the light fantastic and has turned it into a security as opposed to something other than a security. So we're now going to go into the meat of these recent enforcement actions and other things. On slide 7, June 19th, 2020, we had an emergency complaint against Hoodzik Capital and its two promoters, brothers Shane and Sean. And the allegations were a fraudulent raise and misappropriation of money in a fund. It misrepresented past performance and assets, provided investors with false financial statements and forged audit reports. And then the dollars were dissipated into personal digital asset accounts of the two promoters. Well, again, as I said, some of these were scams, and it's pretty obvious what happened here. If someone is forging an audit report, that usually, and I say that tongue in cheek, is a pretty good example that there's something radically wrong of what's going on there. But then also in June, you had the Telegram Group, which is a much more involved and sophisticated business. They had raised over $1 billion by issuing coins called grams, and those grams were held by the SEC to be unregistered securities. Telegram had to disgorge $1.2 billion to the investors, and it paid an $18.5 million penalty to the SEC. Now, there was no admission or denial of the allegations, but Telegram did consent to the disgorgement and penalty and to an injunction. And its promoters and it have to give notice to the SEC before participating in the issuance of digital assets for a period of 3 years. While, again, no admission or denial of liability under the allegations, it did turn out that all of the money was returned, a penalty was paid, and they were effectively enjoined for 3 years from engaging in any of this activity. We're now on slide number 8, August 13th, 2020, Boon Tech. Again, an enforcement action by the SEC. There were $5 million ICO of so-called Boon coins. The Boon coins were issued to more than 1,500 investors in the United States and worldwide to develop and market a platform to connect employers posting jobs with freelancers seeking work. It was represented that the Boon coins were using patent-pending technology to hedge the Boon coins against the U.S. dollar, but no such technology existed. So what was the remedy? A $5 million disgorgement, in addition to $600,000 of prejudgment interest. They had to destroy all Boon coins and issue requests to all third-party platforms to stop trading Boon coins. And the promoter, the individual behind the company, was penalized $150,000 personally and barred from serving as an officer or director of a public company, again, forcing that person into the private placement industry alone. One of those examples where if you're going to represent that you're using quote-unquote patent-pending technology, you better have at least the application in place. Now, my co-presenter here, Evan Katz, used to be an intellectual property lawyer, and I'm not asking you to give a legal commentary here, Evan, but maybe you could just, for our audience, give us a little bit of information about the patent process and why you can't simply make that quote-unquote declaration that patent pending.
Well, patent pending, Greg, is a bit of an ambiguous and somewhat loaded term. So let me clarify for those listening in what exactly the process is. If you have an invention that you believe is patentable, and that means novel and non-obvious, so no one's done it before and it's not obvious based on what people have done, you can file an application in the States with the U.S. Patent and Trademark Office to try to get a patent. And there's various offices around the world, and certain geographies have a common patent system, like in Europe. But if and when you file a patent application, you basically have nothing except a patent application. There's by certainly no means a guarantee you're going to get a patent out of it. So patent pending technology, in quotes, is very ambiguous and unclear because it sort of implies that you're going to be getting a patent, which was probably not the case here. They probably simply filed an application. So I certainly would not recommend that anyone say that anything is patent pending unless perhaps the patent has been allowed and it's literally going to be simply the matter of a passage of time till you actually get the patent. So it seems like the folks here were playing very fast and loose with the language, trying to imply that they were going to get something when they perhaps had no idea whether they might or not, and many patent applications are rejected either because the alleged invention is either not novel, is not obvious, and in the realm of finance, sometimes is simply not patentable subject matter. So it looks like they were playing very fast and loose.
Yeah, and those of you who have followed this series previously know that we've had attorneys from Troutman Pepper, from our intellectual property group, in particular, people who specialize in working with financial services patents. And after the Alice decision a few years ago from the U.S. Supreme Court, it's very difficult to get a financial services process patented. You might be able to copyright it, and you might be able to get other forms of intellectual property protection, but patent, again, that is something that is somewhat more difficult in the current environment. So again, the Boone technology, I think, fits the pattern that I had outlined in the first slide here, talking about the recent trends in the enforcement actions with the SEC. So then we get to Unicorn, which is slide 9, and this came out in September, just 2 weeks ago. Unicorn was the operator of an esports gaming and gambling platform. It raised $31 million in its offering of Unicoin Gold, or UKG tokens. The SEC held that Unicorn had sold investment contracts and failed to register them. The remedy, it had to return all the money and pay a $6.1 million penalty, representing virtually all of Unicorn's assets, effectively putting them out of business. Now, the interesting thing about this case is that Hester Pierce, who's one of the SEC commissioners, the Honorable Hester Pierce, also known as the Cryptomom in a very affectionate way, dissented and said that this action stifled innovation, where there's no allegation of fraud and just an allegation of failure to comply with registration requirements. A different remedy is appropriate, according to Commissioner Pierce. Now, what happened here? They failed to register their coins, but there was no allegation of fraud. Now, what this lays out is almost a strict liability standard. If you fail to register, you got to give the money back, and we're going to impose a penalty. Now, this could mean that the SEC had what they thought was sufficient evidence, but didn't necessarily want to disclose all of it as part of a settlement agreement. Who knows? But the dissent by Commissioner Pierce is very noteworthy and interesting. So when you look at what we have learned from the SEC's actions, Howey is alive and well. It will be used to measure whether or not an attempt to raise money from investors is a security. The likelihood is that a security will be found. And if there was fraudulent conduct, the sword of Damocles is coming down. If it was something that was just an unregistered security, well, at a minimum, you're going to have to give the money back. And at a minimum, you may end up paying some penalty. You may be censured, and individuals may, in fact, be blocked from participating. So the lessons learned whatever it is, it's likely a security, number one. Number two, you're going to waste a lot of time and money if you try to make the argument that it's not a security. So embrace regulation and move down that path. Provide all of the disclosures that are required. Again, disclose, and pick the pigeonhole in which your instrument needs to be. It's either a registered security, in which case you have to go through a full 33 Act registration process or a Reg A plus registration process, or you have to file the Form D, prepare a private placement memorandum, and if you're going to do general solicitation, you've got to invoke 506C and only sell to accredited investors. Again, misconception in that last one, you can advertise to anyone, have open websites, etc., but you can only sell to people who you verified as accredited investors. And then the second shoe to drop in the secondary market, make sure before you try to put anything on a secondary market that you have dotted the I's and crossed the T's. Either the restrictions have lapsed and they are now tradable in the secondary market, or you have registered the securities and have filed your 10Qs and 10Ks and 8Ks, etc., or you are invoking the Jobs Act protections of Rule 506C. So then we move to another area of innovation, which is the merchant cash advance, or the MCA. Here, merchant cash advances are regularly mischaracterized by regulators as loans. They are not. They are forward purchase contracts of future receivables. These are receivables that don't exist yet. So it's like I just bought October oil. And if you're a regulator and you're trying to make the argument that it's a loan, ultimately that should fail when you get into a sophisticated appeals court that understands what these instruments are. I am not loaning money to a quote-unquote creditworthy borrower or merchant. What I am doing is I am agreeing to purchase that merchant's receivables. So I now own those receivables. And if that merchant attempts to divert those receivables to somebody else, that's fraud on the merchant. If the company that issues the merchant cash advance attempts to enforce its rights to those future receivables, it's no different than a pipeline company that bought October oil to be pumped out of the ground by a well, realizing that once October 1st comes, that the pipeline company has failed to connect its well to the purchaser's pipeline. And it's that simple. It's not a loan, it's a purchase of a future receivable. When you understand that distinction, it becomes very important to understand how these instruments are then financed. If a company sells a quote-unquote participation in this, well, that doesn't mean the MCA is a security or its character has changed from that of not being a loan and a forward contract into something else. What it means is you've created a new instrument, namely the participation. Who's booking the bet? Is it still the company that's selling participations? Is this a back-to-back loan concept or some other construct where you're relying on contract law? What happens in bankruptcy? Is the contract deemed to be executory and therefore able to be set aside, and those future receivables are now part of the bankrupt estate, and you become an unsecured creditor? Well, that is a risk. And if a risk is properly disclosed, does that change the complexion of the instrument? Probably. In the Can Capital Enforcement Action, which was filed in May of 2020, Can had raised $191 million from investors through the securitization of a revolving pool of MCA and business loans. Now, as soon as you hear securitization, you need to realize that you've created another investment vehicle. You've essentially created a static fund, but this is a revolving pool. How Can treated non-performing MCAs and business loans was key to investors. Can's used a 32-day non-performing rule, and how it employed that rule is central to the case. Because in every securitization, if the assets that have been placed into the securitization vehicle start to underperform, The investors in the securitization generally demand remedies. One of those remedies is that the promoter has to replace the defective instrument. If the reasons why the replacement rule are not invoked, are not present, then you also need to protect the investor by what's called rapid amortization, where cash flows that come in from the assets go to pay down the waterfall as specified in the indenture that created the securitization in order to protect this more senior instruments, but more importantly, to make sure those who are junior on the waterfall get paid as well. What happened here is that even though CAN said it was following a 32-day non-performing rule, it had granted forbearance to the merchants. And the grace periods that were provided were inconsistent with the disclosure. Because of the use of the non-disclosed grace periods, the securitization failed to meet certain credit enhancement requirements that were designed to limit investor risk and the Class B investors' incurred losses. The remedy here, an injunction, was consented to by CAN, and essentially the securitizations were unwound. Did people lose money? I would assume so, but one of the issues that are always present when you're dealing with these types of assets, and these are alt lending assets, is that default rates tend to be much higher than you would see on mortgages or car loans or commercial loans that are secured by assets or property. Especially in these cases where these are not loans but purchases of future receivables. If the merchant spends the money but doesn't generate receivables, think of about a restaurant that needs $10,000 to buy this week's foodstuffs. It spends the $10,000 and then nobody shows up at the restaurant, so therefore receivables are not created. That's a risk that the merchant cash advance purchaser incurs, and that's also a risk that the participant needs to understand and appreciate. These are very different than some of the other risk profiles that you would see. The second MCA issue that we saw came out in July, and this one is still working its way through the courts and will likely be extremely contentious as we go. This is the Complete Business Solutions Group, DBA Par Funding. Here, there was an allegation that they used a network of unregistered sales agents and affiliated entities to sell promissory notes to the public while lying to or misleading investors about the Par Funding business, how investors' funds would be used, and that the promoters actually had a criminal history. The allegations were violations of Section 17A of the 1933 Act, 10B and 10B5 of the Exchange Act, and Section 5 and 5C of the Securities Acts. One of the interesting things here is they used agent funds to raise money and then funnel that money to Par Funding. So they had investment advisors and broker-dealers throughout the country who are setting up funds using CAN documents provided by the promoter. And then those funds were turning around and buying the merchant cash advances or providing funding to the merchant cash advance company in exchange for some form of participation interest. Again, this is one of those cases where you have all of the securities issues present. You have a lot of allegations. It's going to take a while for the courts to sort it out. But then you also have a bankruptcy trustee that was trying to operate the business who didn't really understand the way merchant cash advances work and the fundamental difference that a merchant cash advance is not a loan. There's no asset there. It's an asset to be created. It's a forward purchase. And so therefore, how all this works out, who knows? But stay tuned. There's likely to be an ongoing saga with respect to Par Funding and Complete Business Solutions. But the message is, if you're going, there's nothing wrong with merchant cash advances. They are a legitimate business. But if you're going to do it, you have to understand the state and local laws applicable. You have to make sure that your instruments are not loans, but rather truly forward purchase contracts of future receivables. And you have to understand that if you raise money from anyone other than yourself, how and when you raise that money likely will invoke the federal securities laws. So if you're selling balance sheet debt, those debentures or notes are likely to be securities. If you're selling participation interest in a securitization vehicle, those are definitely securities. If you're selling participation interests of assets that you continue to hold on your balance sheet, those are most likely securities. And in each of these cases, the fundamental rules still apply. The 33 Act, is it registered or is there an exemption? The 34 Act, you can't engage in fraud, and you can't use persons who are unlicensed finders because that is likely to invoke a rescission right. And if you're using pooled investment vehicles, somebody's got to be the manager of it. Likely that person has to be a registered advisor. If you're taking a profit share, the investors have to be qualified clients, and the fund itself has to fit into an exception under the Investment Company Act of 1940. Otherwise, it has to be registered as a mutual fund or a business development company or a closed-end company of some sort. So there is a path forward. You cannot, this is not a do-it-yourself or DIY proposition. So moving away from the MCA and the other 33 Act type issues, this is one on slide 12 that is, we see people all the time tempted to engage in this activity. And when they talk to their lawyers, if their lawyers are familiar with the Advisors Act of 1940 and other limitations, a red flag should immediately go off. And these are advisor cross trades. In the Palmer Square and settled enforcement action, Palmer Square arranged cross trades among registered and private funds. It managed these funds either as general partner or investment manager, and it did it 351 times between July of 2014 and September of 2016. 351 times. So this wasn't just not a mistake. This was obviously a business practice. In these arrangements, the SEC found that the purchasing side always paid a markup. Again, in normal trade transactions, somebody, purchaser or seller, ends up with a markup in order to pay the broker. There's a rule under the Investment Company Act of 1940 that prohibits cross-trading unless it fits within the exemptive rule 17A-7. The SEC found here that they did not follow the exemptive rule. The interposition of a broker-dealer, even an unaffiliated broker-dealer, did not help. Why? Because Section 48 of the Investment Company Act prohibits doing something indirectly or through an intermediary that you could not do directly. But that wasn't the end of the inquiry. They went after Palmer under both 2063 and 2064 of the Investment Advisors Act. These rules prohibit an investment advisor from acting as a participant on two sides of a trade without first disclosing the role in which it's acting, second, disclosing all pricing information, and third, disclosing the fee that the investment advisor is receiving and getting it approved in writing beforehand. Now, in a registered mutual fund or closed-end fund context, there's a board. That board's not controlled by the manager. It has to be independent. So you could go to the board and ask them for approval. Well, what about in a private fund context? Who acts for the private fund? And the only person who's there is the investment advisor and the general partner, both of whom are also affiliated with the other entity managing the other fund or the other participant in the trade. So fundamentally, you have a difficulty complying with the notice and written consent requirement when you're dealing with a private fund. Now, some unregistered private funds use a thing called an LPAC, a Limited Partner Advisory Committee. Well, if it's a true LPAC advisory, then it cannot act on behalf of the fund because it's advisory. On the other hand, if that's just a nom de plume, and the LPAC actually does have decision-making authority vested in it by the agreement and the other limited partners, now that's a different story. An LPAC that acts on behalf of the limiteds with that fiduciary duty would be able to consent. But again, this is one of those things where the transaction can occur, but you have to dot the I's, you have to cross the T's. Interestingly enough, the SEC and the courts take the position that rules 2063 and 4 apply all the time. You do not need to be a registered investment advisor for them to impose these rules, they apply irrespective of your registered status. 2063 and 4 are very powerful rules that are always lurking out there that requires advisors to have very strong compliance policies and procedures, and to recognize just because they can think it doesn't mean that it should be done. And cross trades have so much risk of quote unquote propping up, buying a bad asset out of one fund in order to prop up its return or its net asset value at the expense of some other pool of asset or investor. So be very careful before entering into any cross trade. Palmer is a very good reminder of what can happen if people ignore the rules. And then the last case I wanted to talk about here in enforcement actions is one that came out of the FINRA National Adjudicatory Council. And this was an enforcement action against a registered broker-dealer in New York. Now, this action has been appealed by the broker-dealer, and so it is somewhat in flux. However, what happened here is very important to understand the position of the SEC and FINRA with respect to so-called sponsored broker-dealer arrangements. It's a very long opinion. I commend it to you. It's available on the FINRA National Adjudicatory Council website. But essentially what they found was that the broker-dealer had split commissions with unlicensed persons. So the broker-dealer had a registered rep. That registered rep, quote-unquote, hung its license with that broker-dealer. The registered rep would earn commissions. The commissions were paid to the broker. The broker paid the commissions to the rep. And then the rep turned around and paid them to its affiliated, wholly owned, in some cases, entity for expense or other purposes. It's that turnover that the SEC and FINRA found objectionable. In order for a fee to be split, and I recommend the opinion to you, particularly around footnotes 25 and 26 and 24, and the text associated therewith, it is clear that it's FINRA's position and the SEC's position that those fees cannot be paid on a gross basis to the affiliate of the individual, and that a sponsoring broker cannot simply give the 1099 to the individual and pay the money to an account set up by that individual's private LLC or other company. That was specifically identified, and the SEC and FINRA have both said, if you want to do something like this, you have to seek a no-action letter. But to be honest, I'm not aware of any no-action letters ever having been issued with respect to this. The broker-dealer was fined for violation of the fee-splitting rule, and they were subject to enhanced supervision and needed to engage a consultant that was going to approve whatever processes they were going to have in place. That consultant needed to report back to FINRA before they could re-engage in business. As I said, this decision has been appealed, and we shall see what happens as part of the appeal process. But it is a shot across the bow and a message to those who think that the broker-dealer rules are anachronisms. They're not. They're there. And again, relatively easy to comply with them. The registered rep gets paid by the registered broker-dealer, and the registered rep pays his own expenses. Pretty simple and straightforward. If they want to move it into an LLC, they do that with after-tax money. Okay, moving on. The Commodity Futures Trading Commission, which has found a new lease on life as a result of changes made by Dodd-Frank, released its enforcement manual on May 20th of 2020. And basically what they did is, in this enforcement manual, they summarized the types of prohibited conduct subject to investigation. So fraud, including fraudulent solicitation, concealment, and misappropriation. False statements to the CFTC, price manipulation, use of a manipulative or deceptive device, misappropriation of material, confidential, non-public information, disruptive trading practice, including disregard of orderly execution, fraudulent trade selection, trade practice violations, trading ahead, prearranged trading, bucketing, etc., false reporting, and undercapitalization. This is a result of the CFTC being given authority, on 10b-5 type authority, to ferret out and enforce actions against fraud in the futures market. Traditionally, as well as spot pricing of commodities. Traditionally, the Commodity Futures Trading Commission only had jurisdiction over a future. Now, if there is fraud in a spot trading of a commodity, they have explicit jurisdiction to go after it. And the compliance manual lays out precisely how they are going to prosecute cases, how they're going to investigate them, the remedies that they're going to seek, and more importantly, these 9 items that they found to be particularly indicative, I guess 10 items, particularly indicative of conduct that they plan on investigating. The CFTC does raise its head in not just commodity futures, but also broad-based, futures contracts based on broad-based securities indices. So the S&P 500 future, believe it or not, is registered by the CFTC. Swaps that have to be traded now on an exchange are regulated by the CFTC. So then the last substantive area I want to focus on before we get to raising capital is the recent focus of the SEC on fund expenses. Now, these issues have originally were found when the SEC first started reviewing private equity funds and small funds, when all managers over certain levels were subject to SEC regulation. In the Rialto Capital Management case, which came out in August of 2020, it was settled without admitting or denying allegations, but they did consent to the SEC orders. The findings were: the matter concerned the manner in which Rialto allocated certain costs and expenses for third-party tasks for 2 real estate private equity funds. The services were asset level due diligence, accounting valuations, and similar services. They found that from 2012 to 2017, they misallocated to Fund 1 and Fund 2 $3 million that should have been allocated to so-called co-investment vehicles. So the fact pattern that they uncovered was you had a fund, then you had a co-investment vehicle, and the expenses for due diligence, accounting, etc., were all being charged to the pooled investment vehicles, the funds, not the co-investment vehicles. Now, they did have an LPAC here, and Rialto had told the LPAC that the costs were at or below third-party charges, but they only did a survey of these rates in 2012 and not thereafter, but they continued to certify that they were in fact at or below third-party charges. And so what did we have? We had a finding of a violation of the Advisors Act, Section 2062 and 2064. Now, the next 2 slides lay out what those 2 sections say in the words of the SEC. But I wanted to highlight, and you can see it in red on slide number 19, a violation of Section 2062 of the Advisors Act may rest on a finding of simple negligence. Scienter is not required. And then they find that because of the conduct, the advisor willfully violated Section 206. And similarly, in Section 2064, a showing of negligence is sufficient to establish a violation of 2064 and the rules thereunder. And so you need to be cognizant of the fact that simple negligence, not scienter, not intent, is sufficient. That means somebody has to be looking over the shoulder of operations personnel, your accounting division, anyone who's allocating expenses, the CFO, and holding them to task under 2063, 2062, and 2064. So, on slide 21, Rialto remediated the funds. They paid back the $3 million to the funds. They promised to cease and desist in committing these violations. They were censured, and they were required to pay a $350,000 fine to the SEC. No tax deduction for the penalty was allowed. And that's actually very important. In all of these cases, the penalties are deemed to be against public policy and therefore not deductible. They don't want you to have the federal government effectively paying a portion of the penalty. So that's the backdrop that we found. That's a quick update on recent enforcement actions that have occurred during the summer of 2020. Excuse me. And now let's talk about a practical reality and why I have my colleague Evan here. Raising capital in a pandemic. If you go to slide number 23, when you're raising capital, whether pandemic or otherwise, all the applicable limitations still apply. So if you're a fund, Section 3C1 and 3C7 of the Investment Company Act provide a definitional barrier. You cannot engage in a general solicitation for a private fund. It means that you are no longer eligible for the exemption from the registration requirements of the 40 Act. What constitutes a general solicitation, of course, is a matter of great debate and has been since the Ralston-Purina case and before, back in 1953, before I was born. So you have to look at Section 4A of the Securities Act of 1933. Have you invoked the safe harbor under Regulation D? Are you only selling to friends and family, people where you have knowledge of the economic consequences so that if it turns out that the investment goes to zero, it will not change their lifestyle? Ralston-Purina is still the standard. And in Ralston-Purina, what we had was a case where a company, Ralston-Purina, was trying to offer treasury stock to its employees, a very large group of employees. And Ralston took the position that it did not have to provide disclosure to those employees since they worked in the business. Went all the way to the Supreme Court, and the Supreme Court basically, following the same standards at the time, said we know a public offering when we see it. This was a public offering. The employees were entitled to the disclosures and protections of the 33 Act. So the other very important thing to take away from here is that if you're using a placement agent, they are subject to the same limitations as you or I. Now, they know more people, and that's why you use a placement agent, and they're experienced in the process. That's why you use a registered placement agent. But they cannot broaden the scope of what constitutes a general solicitation. They cannot give you safe harbor from a violation of Section 3C1 or 3C7. The only way you can do that is you have to invoke Rule 506C, which I mentioned previously, and the rules of Section 506.3 are laid out on slide 24. So I've been talking a long time, and I now want to bring on Evan to tell me some of the things that he has been experiencing as a result of coronavirus. Evan, if I'm in a hurricane, investors may be on hold for a month or two, until the hurricane or the jurisdiction that was affected would be fixed. But coronavirus, I've been working from home for 7 months now. What has that meant for yourself, a registered broker-dealer representative, in your role as a placement agent?
Well, Greg, it goes without saying that the last 6 months have been extraordinary and very different. Initially, I want to say one thing, too, and that is you mentioned the term rescission a couple of minutes ago. And I'm not sure everybody in the audience knows what that is. So, in short, you said not to use unlicensed finders because a fund could be potentially liable for rescission. And to clarify for some of our listeners who do not know what that may mean, is basically it becomes heads I win, tails you lose. So if an investor invests in your fund and the fund is up 50%, everybody's happy, and that's great. But if the fund is down 50% and the investor goes to his, her, or its friendly local lawyer, and the lawyer digs deeper and finds out that they purchased the fund investment through an unlicensed finder, the lawyer and the client then ask for rescission, which basically means to undo the transaction. So they invested $100 million. It's now worth $50 million. They want their $100 million back. In essence, if a fund sells their fund through an unlicensed finder, they're basically giving every investor a free put. So if things go well, everybody's happy. And if it doesn't go well, then those investors theoretically would have a claim to get their money back and individual liability, not only against the fund, but also against the officers of the fund. And even if the fund is the greatest fund on planet Earth, where let's say 85% of the investors made money over time and 15% lost money, that's fantastic. That sounds great, perhaps, but those 15% might have a right of rescission if the fund issued its investments through unlicensed finders. So for those in the audience who may not know what rescission means, now they do.
Well, and this is not just a theoretical risk. A few years ago, there was a case called Blackstreet, where Blackstreet was a fund and was forced to actually give back under a rescission order because they had used an unlicensed person. And then there's also the Ranieri case. And the Ranieri case, same thing. An unlicensed finder was used. They forced the company to rescind and give back the money, and it ended up bankrupting the company. So, as we've seen in other cases like Unicorn, the fact that a company ends up going out of business isn't necessarily something that the regulator cares about. In fact, that may be the actual objective. But no one, of course, is ever going to say that. And even though we have a commissioner, Hester Pierce, digging in her heels and saying, well, there should be a different remedy when there is no allegation of fraud, probably means that most of these things are now going to end up being containing an allegation of fraud, if you know what I mean. And your point about a regulatory put is a really, really important point. In my experience, when funds are up, the investor says, that was great. Look how smart I am for picking this manager and this fund. When values are down, the investor will often not take responsibility for their investment decision and will suggest that there was fraud. And so you don't want to create a situation of someone having a regulatory put simply because you cut a corner and used an unlicensed person. So again, let's go back, Evan. As a placement agent who is used to pressing the flesh, going to cap intro events, hosting them, talking with people, how has coronavirus changed your world?
Well, sure. It's obviously been extraordinary. So clearly, in March and April and early to mid-May, everyone, hedge funds, other funds, investors were, simply trying to figure out how to go safely to the grocery store. Are their kids' schools open? And where in the world do I find N95 masks? So clearly, for a couple of months, things were completely on hold. The last several months, though, has been very different. As the world has, to some degree, and I'll put this in quotes, gotten adjusted to coronavirus, because clearly this is what I call the new abnormal, things are getting back on track with fundraising. So as the world has adjusted somewhat to coronavirus and everyone's become a Zoom expert, we have seen a substantial uptick in investors conducting virtual meetings with funds using Zoom and other equivalents. And this has not only been a substantial uptick in just investors getting back to business and doing due diligence on funds in general, but also a huge increase in the number of cap intro events. These are the professional events that prime brokers put on, that certain third-party conference companies put on. And basically what it used to mean before coronavirus is that dozens or hundreds of funds or investors had to get on a plane and go to a nice hotel, sometimes in the winter in Florida, as several of them do, or in New York City. But obviously, that's a time commitment on behalf of the funds and the investors, and also some expense in being out of the office and so forth. What we're seeing now is, in addition to a lot of investor one-on-one due diligence and conferences, virtual with hedge funds and other managers, is we're seeing basically almost a monthly cap intro event in the industry going on. Every single month, a huge cap intro event where investors from around the world, not just the U.S., are doing meetings with managers they want to meet virtually. And so in a small way, now that everyone is up to speed on Zoom and technology, and a lot of the conference companies and cap intro groups have built out their platforms, in some respects, there's actually been a huge uptick in the amount of cap intro events that are going on.
But that's an interesting question. You always wonder and are always concerned that if someone doesn't have to get on a plane or set aside a couple hours to travel or incur the expense to go to an event, that they will be less motivated, and that all of a sudden attendance at multiple cap intro events becomes attendance at multiple CLE events, if you know what I mean. So how do you defend against the people who are dabblers and just, tune in but then never commit?
Sure, that is a great question, because sometimes if you have to invest the time and money to fly 500 miles or 1,000 miles, you've got more skin in the game, as they say. I guess there's been two factors. One, as with many of these events, the hedge funds and other funds have to pay to participate, so they've invested their time, and obviously they're looking to get more investors and to increase AUM. And what I've been hearing from a lot of the investors that I speak with on a very regular basis is they're going for a couple of reasons. To your point, if this were a hurricane or a tornado and it was a month of cleaning up, everybody would sit on the sidelines for a month. But what the investors are telling me, and we work with and speak to hundreds of institutional and family office investors, what they're saying is they can't put investing on hold for a year or 18 months or who knows how long this is going to be happening. So when they do accept invitations to cap intro events, the vast majority are pretty serious because they're looking to put capital to work. They've got dry powder. They need to find the next great hedge fund, private equity fund, real estate fund, or what have you. And not to get too into the weeds with cap intro events, but as the organizers tell me frequently, if an allocator goes to several events of theirs and doesn't allocate, they will be removed from the invitation list for the next one or asked to step up their game a little bit. So you're absolutely right, Greg. I mean, not everybody is going to be as invested as if they flew thousands of miles or hundreds of miles, but the vast majority are there to do business. And unlike the cap intro events in person that I've gone to over the past decade or more, there's no free cocktails and there's no free hors d'oeuvres. So most of the folks that are going, most of them are looking to do business at this point.
Well, and that's actually a really good point. Cash is not really an option, right? With interest rates at all-time lows, with treasuries less than 1% for now and well into the foreseeable future, cash is literally a liability and will drag down IRRs. And so you do have anyone with dry powder looking for the right opportunity. And of course, the problem with volatile markets is any public securities could be up 5 today, down 20 tomorrow, up 30 the next day. And so private assets that are not publicly traded, where there is no public mark, tend to provide a better investment point, if you will, for investors who are afraid of the volatility. But that really is, I think, a false sense of security, because if you invested in an illiquid fund, then you have to be invested for the full time horizon. And if you try to turn to cash or go to cash, you will either be blocked by the general partner or get a price that is going to be nowhere near what you think the value of the asset is. So, these are all trade-offs, which is why the 3 rules of investing apply here. Disclose, disclose, disclose. Make sure investors understand. Make use of a little function in Outlook called the option. You click on options and you get a read receipt. You get a delivery receipt of the emails that you sent out. You never know when that receipt is going to be useful for you when you told an investor about this risk or that risk as part of an overall offering and potential investment. So I'd like to also pick up on one of the other things that you had mentioned, Evan, and that is Zoom. And the fact that now we've all become very comfortable with Zoom or Microsoft Meets or whatever Teams or whatever software package you're using, and I think I use them all at this point. How is that going to affect the future? Is it now going to be de rigueur that you first have the email introduction, then you have a Zoom call, and then from the Zoom call you're going to have to go out and press the flesh? Is this just another way for investors, especially institutional investors and gatekeepers, to delay the process? We've all heard the family office managers say, oh, I'd love to invest in your fund, if only it were bigger. You say, why? Well, I'm only allowed to write $10 million checks, and I can't be more than 10% of your fund. And so immediately what that means is they're not investing unless you're 100 million. You go back when you're 120, all of a sudden that standard's been changed to 200. So, the gatekeepers have whatever rules they have. They're imposed by the managers. Evan, how do we leapfrog those gatekeepers?
Sure, Greg. Well, you've raised several points and raised some good questions. So a couple of things. Let me just unpack that a little bit. At this point, the overwhelming majority of investors we're speaking with will be allocating and are allocating to managers without an in-person. Now, obviously, they're still doing substantial ODD, going through documents in virtual data rooms, doing the standard background checks, service provider checks, and so forth. And, we've even heard of some situations where, with regard to some documents that are super sensitive, that people used to show investors in the office only, they're very most secret sauce type of documents. They'll occasionally hold them up to a computer screen or show them portions. But as a matter of necessity, investors are allocating based on extensive due diligence, and the bar may be higher even without a meeting. Now, that requires one big clarification. I was on a panel last week with some top allocators, and one of the gatekeepers made a good point. That is, well, we've probably seen these managers, or we know them, or we know their fundraiser from a prior life, or we've had prior meetings and calls. So I think it's critical for hedge and other funds that are looking to raise money during the pandemic to make sure that one of the fund partners or their fundraiser, internal or external, already has substantial prior relationships with the investors, not only for regulatory reasons, not only for the obvious reasons that you're vastly more likely to raise capital if your partner or fundraiser knows these people for years on end, but also specifically in a time of coronavirus where the vast majority of funds who are getting allocations based solely upon Zoom and extensive virtual data rooms, not surprisingly, are the ones where their partners or their fundraiser has had prior meetings before coronavirus for years or decades with the investors. So that is definitely critical. And one more thing you raised about the minimum size funds and the gatekeepers and so forth. Many of the largest investors and even some medium-sized ones do have gatekeepers and advisors. Some use them for advice. Some of them have discretion. And there's really no way to end run them because they do have a critical role. The best approach really is to make sure that your partner or fundraiser knows, like I do, knows the gatekeepers and the consultants as well. And that doesn't mean you can't approach your friend at the pension or the endowment, which I do. And if they like what I show them, they're going to have their gatekeeper take a close look at it. But it's good to also make sure that you know the gatekeeper as well as the fund, because if you get both of their interests, you have a much greater chance of a close than if you just know one of them. And lastly, regarding the asset level, you mentioned, the allocators who can't be more than X% of a fund, and therefore it becomes a chicken and egg. There are allocators that look specifically to or otherwise are open to investing in so-called emerging managers. So there are allocators, and we work with plenty of them, that will consider emerging managers under 100 million, under 250 million, whatever the definition is these days. And that's a critical thing to make sure that you, the partner, or you, the fundraiser, or the third-party marketer you hire, if you are an emerging manager under X dollars, that your fundraiser knows, emerging manager investors or investors that'll consider emerging managers. So if you're a $100 million fund and you hire a great fundraiser who's been at a $10 billion fund, he or she is probably not going to know too many investors that allocate to emerging managers.
Okay, well, it looks like we have reached our 1 hour time. Evan, I'd like to thank you for joining us. I'd like to thank our audience, both live and on tape, for their attention this afternoon. Certainly, if you have any questions about any of the topics covered, feel free to reach out to me, Gregory Nowak, gregory.nowak@troutman.com, or you can dial my telephone in New York, 212-808-2723, or in Philadelphia, 215-981-4893. Or Evan, you want to remind everyone your contact information?
Sure. It's Evan Katz, Crawford Ventures, phone number 212-904-0909, and the email is ekatz, E-K-A-T-Z, at crawfordventures.com.
And Evan, you want to just mention your broker-dealer affiliation?
Sure. Broker-dealer affiliation is BA Securities.
Okay, so all securities offered through BA Securities. Okay, thank you again for your attention. Have a great day, and we'll see you next month.
Copyright Troutman Pepper Hamilton Sanders, LLP. These recorded materials are designed for educational purposes only. This podcast is not legal advice and does not create an attorney-client relationship. The views and opinions expressed in this podcast are solely those of the individual participants. Troutman Pepper does not make any representations or warranties, express or implied, regarding the contents of this podcast. Information on previous case results does not guarantee a similar future result. Users of this podcast may save and use the podcast only for personal or other non-commercial educational purposes. No other use, including, without limitation, reproduction, retransmission, or editing of this podcast may be made without the prior written permission of Troutman Pepper. If you have any questions, please contact us at troutman.com.